Assalamu alaikum. For continuity of our course, we are going to discuss today confidentiality. Confidentiality is an essential part in the exam, and a lot of cases we usually face it during our exam or our daily activity. So we will go through this meeting to discuss the confidentiality. Confidentiality if the patient has capacity, confidentiality if the patient lack capacity, confidentiality that required by law, or confidentiality after death of patient. All these circumstances could be face us during exam, and I will go in details to speak about each situation that we can face it. Confidentiality. Let's start by speaking about introduction. Confidentiality is a center to trust between doctors and patient. Without assurance about confidentiality, patients may be reluctant to seek medical attention or to give doctors the information they need in order to provide good care. But appropriate information sharing is essential to the efficient provision of safe, effective care, both for the individual patient and for wider community of patients, so that confidentiality is the trust between doctor and the patient, and you have to convey this message to the patient. You are keeping his medical information in a secret manner. The assumption that confidentiality is always paramount is as inappropriate as the assumption that disclosure is always permissible, and the decision will need to be tailored to the individual circumstances of the case. Seeking a patient to consent to disclosure of information shows respect and is a part of good communication between doctors and patient. So, in this slide we are speaking about the patient consent before disclose of medical information. Health professional or health care provider is involved in such cases may feel a three-way tension between first part respecting an individual confidence, communicate potentially beneficial information to other family member, and third part respecting the possibility that those family members may not want to receive such information. This is about the patient confidentiality. We are facing three problems: respecting patient wishes, and respecting the possibility that those family member may or may want to receive such information, and communicate beneficial information to other family member. Where treatment will be instituted or altered. Genetic test of children is likely to be appropriate. Again, genetic test of children is likely to be appropriate. However, where the test will not be a medical benefit for the child or to the child for some times, the recommendation suggested a presumption of delay until a child is old enough to choose for him or herself unless there are compelling reasons to test earlier. So for genetic test for children, we have to outweigh the benefit of the doing test early, and if this test will lead to a change in the medical condition of patient or will prevent the complication could be happen to the patient, so that we will put the genetic test is if it is benefit to do for a child or not. The benefit is if we did it early, we can treat the condition early or prevent the complications from this problem. I will give an example for this, like patient with cystic fibrosis. If we diagnosed early the patient, we will go through medical management to delay and prevent some complications. So that it is one of the most ethical dilemma. Are you going to do for this patient genetic test or for this child genetic test or not? So that we are going to do if there is any medical benefit for the child to doing the test early. If a patient refuses consent to disclosure of his information, you will need to balance your duty to make the care of your patient your first concern against your duty to help protect the other persons from serious harm. Also, this problem we have to gain it and put it in our mind. If the patient refuses to disclose his information, we have convey message for the patient that we are concerned about his medical management more than to protect other person from serious harm. Here I will give an example. One of this example is if you have patient has HIV, and according to the laws and the regulations, you have to inform him that he has to inform his partner. But if the patient insists to refuse to inform his partner, so that you have to explain to him what is the benefit to inform his partner and what is the sequences could be happened if he didn't inform his partner. So you have to reach to a compromise solution with the patient. Don't tell him I am going to inform my partner, your partner, about your medical problem. Let the patient to share in the decision, so that you tell the patient, if you don't like to tell your partner, please you have to use some protection during intimate relationship and think in this issue, and after some times we can discuss this again, but let us now to concern about your medical treatment, so that you convey the message well to the patient that first concern is the patient, to manage the patient, and second concern to protect the others. So don't waste your time to try to convey the patient, to convince the patient to disclose his information other than his medical treatment is our first concern. Now, when do you have to disclose confidentiality? When we are going to disclose confidentiality, confidentiality is an important duty, but it is not absolute. You can disclose the personal information if, so that it is our duty to keep everything confidential, but not everything is absolute. In communication, there is a message you have to put in your mind. nothing is right all time. Nothing is right all time. Every case is a different than other case. So it is not absolutely contraindication to disclose on confidentiality. So when do you have to disclose confidentiality? First, if it is required by law. Second, the patient consent. Either this consent implied consent or express consent. Or number three, it is justified in public interest. We have now three reasons to breach the confidentiality. Is if it is required by law, if it is justified in public interest, or patient consent. This consent could be implied consent or expressed consent. We have to go through steps for disclose confidentiality. When disclosing information about the patient, you as a healthcare provider must use coded information if practical and if it will serve the purpose. So that first we have to use coded information so that during discussion with the patient about confidentiality and this patient will say in research, we have to be sure to inform the patient your personal information will be coded and will use the code number for your case. Number one, use code information. Be satisfied that we have to be satisfied that the patient has ready access to information that explains that their personal information might be disclosed for the sake of their own care or for local clinical audit and that they can object. Other step is hasn't objected. The patient didn't refuse to disclose this information. If we are going to disclose information like medical research, we have to use code. We have to take a consent from the patient, and the patient didn't object to disclose information. We have to get the patient express consent. Express consent, it is written consent. If identifiable information is to be disclosed for the purposes other than their care or local clinical audit, unless the disclosure is required by law or can be justified in public interest. For clinical information to share with other persons, other medical team members, to be specified, other medical team member, we can use implied consent. But if we are going to use this information away from the medical team or local clinical audit, we have to take express consent from the patient unless it's required by law or justified in public interest. We have to keep the disclosure to be minimum necessary. We have to keep up to date with and observe all relevant legal requirements, including the common law and the data protection legalization. Data protection legislation. Disclosure required by law. You must disclose information to satisfy a specific constitutional or statutory requirement, such as notification of known case suspected of certain infectious disease. If you have patient has tuberculosis, it is required by law to inform the NHS about that. We have to disclose the information if it is required by court. If there is law or required by court, we have to disclose information without consent from the patient. Very important thing, you mustn't disclose personal information to third party, such as solicitor, police officer, or officer of a court without the patient express consent, unless it is required by law or can be justified in public interest. Sometimes in the exam you will face that the patient will inform you, doctor, please didn't inform the company about my medical problem. Yes, he has the rights for that. We will not disclose confidentiality unless it is required by law. If the patient has tuberculosis, we have to inform his company, because to inform NHS and make tracing for the contact. But at the same time, if the patient has hypertension, we didn't have the right to disclose the information to his company, as if it is not required by law or not justified in public interest. Confidential medical care is recognized in law as being in the public interest. However, there can also be public interest in disclosing information to protect individuals or society from risk of serious harm, such as serious communicable disease or serious crime. Before disclosure of information, there is important issue. We have to inform the patient we are going to disclose his information. Actually, if in exam and you face a case of epilepsy and you try to convince the patient to stop driving, we have a lot of steps in this issue. First, we have to express for your patient, what do you think if you lose your consciousness during activity? Do you think it is a harm for you? This is very important to start with the patient for that. And tell the patient this attack could be happened to you at any time without any previous complaint, so that if it's happened to you during driving, you will be danger for yourself. Please see this issue. Please listen for this issue. First concern is your patient. Try to convey the message for that. Didn't tell the patient if you make an accident you will be harmful for public. No, start by the patient. If this attack happened to you during driving, you will be harmful for yourself and you may be lost your life. So we are going to make you live in a safe environment. This is a very, very important issue we have to discuss with the patient. After that, tell the patient this you may be harmful also to other persons. If the patient is married, tell him, suppose that this attack happened to you during drive and your kids with you in the car, so that it could be a problem for your kids. If the patient till now is still not convinced, tell him if you will continue drive after now, your license will be invalid. It is not a drive license, it is not a vehicle license, but also insurance license. So that you have to tailor and go step by step. If the patient refuses after that, tell the patient please, can you stop driving for a couple of weeks and think in this issue and and we will discuss this issue in the next meeting. This is the way during discussion with the patient. But if the examiner going to discuss with you, tell him if the patient is still insist to refuse driving, to refuse stop driving, we have to inform DVLA. I am the one who have to inform DVLA, and before inform DVLA, we will document that in his file. I informed the patient to stop driving, and at the same time I have to inform the patient that I am going to disclose his information. So that you should inform the patient you are going to disclose his information. That is the right of the patient. Again, this is one of the wisdom in communication regarding the confidentiality. You must weigh the harms that are likely to be arise from non-disclosure of information against the possible harm, both to patient and to overall trust between doctors and the patients arising from the release of that information. Please don't lose the trust with your patient. Try to reach to a compromise solution for the problem. If the patient doesn't like to stop driving now, give him 2 weeks and discuss that in the next meeting. If the patient doesn't want to inform his partner about HIV, give him a couple of weeks, use protective intimate relationship, and after 2 weeks you can discuss and raise the issue again with him. So you have to outweigh the benefit and risk of disclosure of information. Next, if the patient lack capacity, if the patient doesn't have capacity, when making a decision about whether to disclose information about patient who lack capacity, you must make the care of patient your first concern. Again, our first concern is the patient, not other public, not other people, not person, not relative. This message we have to convey it well to the patient. Make the care of patient your first concern. We have to respect the patient's dignity and privacy. We can involve the patient later before disclose of information if the patient capacity is temporarily lost. We have to define if the patient lacking capacity is a permanent or a temporary. If temporary, if permanent, and if it is permanent lacking capacity, we have to outweigh the benefit of disclosure of information. But if the temporary losing capacity, whether the decision to disclose information will be reasonably wait until they regain capacity. I mean here, if the patient lacking capacity for temporary cause, we have to make a plan. If disclose information will give a benefit or not. If will give a benefit, we have to disclose it. If not, we have to wait until the patient regain his conscious or his capacity. We have to respect the patient's previous expressed wishes. If the patient has any advanced directive or living will, we have to respect it. Also, to check the view of the other close to the patient, like last attorney, that maybe it is appointed by the patient to take the decision on behalf of him. As we know that consent could be implied consent or express consent. Implied consent, maybe the patient can give us implied consent to disclose his information, especially during share information with the healthcare team or with other providing care. If you are taking care of patient, we can take a verbal consent from the patient before sharing information with other healthcare provider. Like patient has tuberculosis and you informed him you have tuberculosis. When you finish the discussion with the patient, tell him I will inform the TB nurse. I will inform the tuberculosis nurse and GP. If the patient doesn't object, that is mean he give implied consent. So that most of patients understand and accept that information must be shared with the healthcare team in order to provide a good or a comprehensive plan of care. You should make sure information is readily available to patient, explaining that unless they object. If the patient refuse, that is right for the patient to refuse, but we have to try to convince this patient to take a consent. We must respect the patient wishes, and if the patient objected to personal information to be shared with healthcare team or other providing care, unless, again, every now and then you will listen this issue, unless disclosure would be justified in public interest. If a patient objected to a disclosure that you consider essential to the provision of safe care, you should explain to your patient you can't refer them or otherwise arrange for their treatment without disclosing information. If you are going to inform the patient that I will refer you to the surgeon and I will tell you about his condition, and this surgeon will share in information and share in medical treatment, and if the patient refuses to share his information, you have to inform him your care will not be comprehensive and it will affect your care. For implied consent, circumstances may arise in which a patient can be informed about the disclosure of information. For example, in a medical emergency, in such a case, you should pass relative information clearly to those providing the patient care. If and when the patient is capable of understanding, you should inform him that how their personal information was disclosed, and if it was in a way they would not be, they wouldn't expressed or reasonably expected. In this paragraph, we will not face an exam. Actually, the patient will do the best interest for the patient if the patient lack capacity. Number one, as we said about the breach confidentiality after implied consent. Number one, it was for sharing his information with the medical team. Number two, for local clinical audit. Maybe will disclose identifiable information, provided you are satisfied that the patient doesn't have any object to share his information, and we explain to the patient about the local clinical audit and what they have to be the right to object, like in research. If the patient does object, to disclose his information, you should explain why this information is needed and how this may benefit for his own and other care. If it is not possible to provide safe care without disclosing information for audit, you should explain this to the patient and the option open to him. For disclose information, we have that taking the patient consent. We have to take the patient to consent, either verbal or implied consent, before disclose his information, unless it is required by law or public interest. Disclosure for which express consent should be sought. Express consent. You should seek a potential express consent before disclosing identifiable information for purposes other than profession of care or local clinical audit. So, in summary, for local clinical audit and for care of the patient with other medical staff, no need to take express consent. Implied consent is enough. If the patient refuses consent, or if it is not practical to get their consent, information can still be disclosed if it is required by law or can be justified in public interest. If the patient refuses to give a consent to disclose his information, we can disclose this information if it is required by law or in public interest. Again, we will go back to genetic information. Most patients were ready. All patients usually in the life or during daily activity will share information about their own health with their children or relative, particularly if they are advised that it might help those relative. If we are going to inform the patient about genetic illness, we have to tell him, please inform your relative. If we found the genetic illness could be autosomal dominant condition, you have to tell her, you have to inform your brothers and sister, because one of them could have the disease and he didn't know he has this disease, so that we can get a prophylaxis for him or try to know if he has a problem or not. So that the benefit to inform the relative, we have to inform the patient to inform the relative why. To get a prophylaxis or other preventive treatment or intervention for those relatives could be affected by the disease, make use of increased surveillance or other investigations, prepare for potential health problem. So that we have to share information with the patient and inform him. He has to inform the relative. He should inform the relative why, to get a prophylaxis or to avoid serious complications. Maybe we'll give a preventive treatment for him. However, some patient might refuse to consent to disclose of his information that would benefit to other relatives. In these circumstances, we have two options. Disclosure could be justified in public interest, it is one option, or we have to outweigh the benefit and risk and reach for a compromise solution. I mean here, if the patient refuses consent to disclose, you will need to balance your duty to make care of your patient your first concern against your duty to help protect the other person from serious harm. Again, I will tell the patient, I am going to tell you this medical problem could be serious problem, and we have to concentrate to prevent the progression of this disease and to treat any symptoms could be arise. But also we have to put in our mind this disease could be affect your brother or sister, and we have to inform him to make a test to check if they have a disease or not, because we can prevent this disease from progression, or we can give him a treatment to settle this disease before it be manifested by serious complications. This is only an example I discussed. Sometimes there is no any prevention of progression of the disease just transmitted through genes. So we have to convey a message for the patient. The patient, you are the first concern of us. Now, we already mentioned about the patient has capacity, the patient lack capacity, or the patient, when the patient we can take from him verbal consent or implied consent, and when we have to take written consent. So also we shared genetic information, and we told it could be justified in the public interest, or we can outweigh the benefit and risk of information, and tell the patient you are the first concern for us, and try to reach a compromise solution with the patient. For the patient has been died. The patient has been died. We can breach his confidentiality? Could be. For example, if this information will help the coroner, so that we can breach the confidentiality to the coroner. When disclosure is required by law or justified in public interest. Number one, if it will help the coroner, or justified by law or public interest. Maybe for this certificate, yes, it should be completed honestly and fully. For local clinical audit, how many cases this by heart attack, we can breach the confidentiality. So that for this, we can breach the confidentiality to the coroner if it is justified in public interest or by law, or if it is used for clinical audit by National Health Service, or this certificate should be or must be complete honestly and fully. When a partner or close relative or friend asks for information about circumstances of an adult death, and you have no reason to believe that the patient would have object to such a closure. For the public health surveillance, in which the case the information should be coded unless that would be deviate the purpose. When a parent asks for any information about the circumstances related to death of a child. So that for a child, if the parent asks what is the cause of this, we can disclose his information. Or for local clinical audit, or if we didn't feel there is no objection from the patient to breach the confidentiality of his illness to his relative, or it is justified by law, or it is justified by public interest. This is the items we can breach the confidentiality of the patient after he passed away. Now, in summary, confidentiality is a trust between a physician and a doctor. If you lost your trust between you and the patient, you will lose a lot of information that is in practical life. You have to keep all information confidential unless it is required by law or it is justified in public interest. This is a message for all. All information should be kept confidential confidential unless it is required by law or public interest to disclose it. You have to take a consent from the patient before disclose his information. This consent could be implied consent or express consent. Implied consent in the medical health during discussion with the other clinical care provider or health care provider, and also for local clinical audit. But there is two items we can disclose information with implied consent: for discussion of the case with the other clinical team member or for clinical audit. Express consent usually will take it if this patient will participate in the research. Before disclosing information, you have to inform the patient you are going to disclose his information. Try to reach for a compromise solution with the patient and didn't go with confrontation with the patient. Didn't tell him in the exam you have the right as a doctor to disclose his information. If he insists to refuse that, this is a practical. This is not a practical way in communications. We have to give the patient opportunity to think and give him a chance to think, and you can arrange a meeting after couple of days or week and discuss this issue again. When we have to inform the patient that you can avoid driving for 2 weeks until we discuss this issue again, or you have to use a barrier in your intimate relationship to avoid transmission of the disease like HIV or HPV to your partner. Disclosure for information for other third party like companies, solicitors or relative. It is not right to disclose the information to other third party without consent from the patient. So that usually when we are going to discuss a case in the communication and his relative is discussing the case with us, we have two options. If the patient has capacity or not has capacity. If the patient has capacity, we have to inform the relative if you have a consent to discuss the condition with us or not. And we have to tell him in a polite way, as I said before, I believe that you have a consent from your father to discuss the condition with me, if the patient is conscious. But if the patient is unconscious, just only, are you next of kin of Mr. Ali? Yes. And if the examiner told us, but the patient doesn't have the patient doesn't give consent to his son to discuss the condition with you, how come you discussed and breach some confidential information to his relative without consent of the patient? At this time, we can reply for the examiner, I discussed the case of the patient with him because for this patient lacking capacity, and we are doing best interest for the patient. And one of this best interest of the patient to know the patient wishes from his relative. We can also breach the confidentiality after this, like it is required by law or public interest for clinical audit, or if we didn't feel the patient doesn't object to disclose information to his relative, if the child death and the parent want to know some circumstances about their child illness. This is a confidentiality. And also we spoke about the genetic information, and we have to try to convince the patient to inform his relative about his genetic illness, because this genetic illness could be preventive if we found it early, or could be avoid the complication of some treatment started early, or delay the progression of the disease. So that we have to convince the patient to inform his relative about genetic illness or his partner. And if the patient refuses to disclose information, again don't go in confrontation, and let the patient to think in this issue for a couple of weeks, and we can discuss the issue later. This is confidentiality. I hope that it this confidentiality lecture will help others to understand the confidentiality statement, and when we have and to breach a confidentiality, and when we have to take a consent, and how can we reach for a compromise solution with the patient if the patient insists to refuse the confidentiality, and continuous meeting with the patient until we reach for obstacle. This patient will not inform his partner about his problem like HIV, so that this is the way we'll discuss with the examiner. He will tell you if the patient insists to refuse to breach the confidentiality, what are you going to do? You will tell him, I will try to convince, I will make another meeting, and I will try to explain more and more. But the examiner will tell you if he insists to refuse to breach the confidentiality. Here you are going to inform the examiner, to the examiner, I am the one who breach the confidentiality, and before breach the confidentiality I have to inform the patient I am going to breach his confidentiality. This is confidentiality statement, and keep everything secret between us. Confidentiality is one of the major ethical dilemma in exam. Please didn't inform anyone about this statement. Confidentiality is one of the ethical dilemma in the exam. Keep this confidential between us, and see you later in the next lecture. I hope this lecture is helpful for others, and thanks again for Dr. Khatib for the effort that he are going to do after I submit for him this lecture. And at the same time I am going to prepare for next lecture. It will be breaking bad news pathway. Thank you. See you. Bye bye.